parties are adequately protected throughout the arbitral proceedings. It provides recognition for the arbitration agreement, and deals with appointments of the arbitral tribunal. It clarifies the limit of judicial review of the arbitral process, particularly actually so that the court mechanism is not used to delay the arbitral process itself. Sometimes I think that's one of the problems that we've been facing, and I think it's been changing now. And then, very importantly, the awards given in arbitration are actually final and binding, and there is a platform for the enforcement of such awards. Now, in international arbitration, which we are all interested in, the arbitral legislative framework, actually there's a focus nowadays to actually go towards a uniform harmonization, and a lot of the legislation is actually based on UNCITRAL model law, so that there is a similarity across the various jurisdictions. So we are very, very fortunate today that we have a panel of distinguished speakers who will guide us through the legal framework for arbitration in the various jurisdictions. And the format that we have is that we have 4 speakers, Mr. Chan Ling San, Mr. Gary Su, Mr. Lau Hang Chong, and Datuk Davidson, Bill Davidson. And each speaker will be given 15 minutes. And after 15 minutes, I think we'll be try to stick to the time. And then we'll have 10 minutes for questions and answers. So I'm delighted to actually introduce our first speaker, Mr. Chan Ling San, who is qualified in Malaysia, Singapore, and England. He is a partner of Ang & Partners since 1995. He is also adjunct faculty for International Commercial Arbitration at the Singapore Management University School of Law. He has served as legal officer for the United Nations Compensation Commission in Geneva, and is a SIAC, CIAC observer at the UNCITRAL Working Group on Arbitration. He chairs the Singapore Law Society ADR Committee and sits on the Singapore Institute of Arbitrators Education Committee. Of course, he sits as an arbitrator and adjudicator, and is on the panels of various institutions. And he's also, he's a distinguished scholar. He has got a lot of scholarships. He's he was a Cambridge Pegasus Scholar, Koch Foundation Scholar, and Honorary Shell Scholar. Can we please welcome Mr. Chan?
Thank you, Mr. Chairman, distinguished guests, friends, ladies and gentlemen. Good morning. Now, well, a bit of good news and bad news kind of starting first. In your CD-ROM, there will be some statutory extracts that I had prepared, referring to the relevant provisions, which I will speak about in the course of this presentation. That is the good news. The bad news is that you don't have them printed out before you, so you can't refer to them as I speak. But that is also good news for me, because that means I can misquote and miscite whatever provision I like and not be challenged. Although I know that there's one lawyer from Singapore who is quite preparing to ask difficult questions. Okay. Now, what I will talk about here, as the theme suggests, will the overview of the Singapore legislative framework. Okay, and it is quite pertinent as well for this forum, because Malaysia itself has the Arbitration Act substantially revised or reenacted in the form of the 2005 Act. And as we go along, there will be a need to review whether the Act is working as intended. And that was the experience in Singapore as well. So let me just give you an overview of what we have in Singapore. Okay, it's not coming up. The other button. Okay, sorry, give me a second. Which button? Masking tape. No, it's going backward. Maybe you can control it from there. Okay. Well, there are 3 statutes in Singapore. The first one that I'll mention is the International Arbitration Act. okay, which will govern international commercial arbitration. There are two important instruments that are given effect in Singapore under this statute. One is the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, and the second would be the Ancestral Model Law on International Commercial Arbitration. This act will apply by default if the nature of the arbitration falls within the character of international as defined in the Ancestral Model Law, which would be familiar to most of you, so I will not elaborate on that. And if your arbitration does not fall within the International Arbitration Act, by default, if it is held in Singapore, it will fall under the Arbitration Act. The Arbitration Act is meant to govern domestic arbitrations, but parties arbitrating in Singapore do have a choice. They can either arbitrate under the IAA or the AA if they expressly provide that they wish to do so under either statute. So if your arbitration is international in nature, you can still opt to arbitrate under the AA by opting out of the International Arbitration Act or the Ancestral Model Law. Likewise, if your arbitration is domestic in nature, you can still opt for arbitration under the International Arbitration Act. Now, what's the difference between these two? What's the point of having two statutes? There are a few differences. Two main differences that I want to highlight here is that under the International Arbitration Act, under the Ancestral Model Law, there is no right of appeal from an arbitral award. Okay? You may challenge an award by way of applying to set aside the arbitral award, and as we all know, that would be on very limited grounds stipulated in the Ancestral Model Law. Okay? Under the Arbitration Act, there is a possibility of appeal, but the right of appeal is subject to stringent conditions. For English practitioners and common law practitioners, you know them as the NEMA principles. The NEMA principles have been given statutory expression in the Arbitration Act, and that is, if you want to appeal from an arbitral award, you must show that the tribunal was obviously wrong on a question of law. The appeal is only on a question of law. Okay? But if the question is one of general public importance, the threshold is lower. You have to show that the tribunal's decision was at least open to serious doubt. Okay? So you still have to cross that threshold before you can appeal. The other difference is that under the Domestic Arbitration Act, there is retained this avenue for recourse to the court to decide a question of law during the course of the arbitration proceedings. So reference to the court on a point of law is possible under domestic arbitration. Okay? We know that in Malaysia, the Arbitration Act has sort of merged the two regimes into one. For international arbitration, there's no right of appeal, but for domestic arbitration, you still have this possibility, but you combine it into one statute, right? In Singapore, you just have them separate. The third statute that is also dealing with arbitration in Singapore, though not so much for the commercial kind of disputes, would be the Arbitration International Investments Disputes Act. That gives effect to the Ancestral Convention on the settlement of disputes between states and nationals of other states. Okay. Basically, it is tailored to the exit arbitration regime which is run by the World Bank, dealing with investment disputes. Okay? So if there is an exit award, it can be enforced in Singapore and can be enforced by the High Court if it's against the government. Okay? Happy to say that in Singapore, although Singapore has hosted exit arbitrations, it has not been the subject of any claim yet. Okay? What we are concerned mainly here would be the IAA and the AA. Over the course of the years, these two statutes have been constantly revised, okay, because no drafting techniques are perfect, and the best draftsman cannot anticipate every problem that could arise. So what is very useful and beneficial to arbitration practitioners is that these statutes are constantly revised and monitored to see whether they are being implemented or being interpreted the way they should be. And sometimes courts do come up with decisions that do not quite meet the expectations of the community. So I would just mention a few examples here. Well, let's deal with the Arbitration Act because it underwent very substantial revisions in 2002. Prior to that, the Arbitration Act was modeled on the old English Arbitration Act of 1950. So it was pre-ancestral model law, did not quite incorporate some of the more modern concepts that the global community later adopted. So by 2002, it was very obvious that it was out of sync with the international community, as well as with Singapore's own International Arbitration Act. Because the International Arbitration Act itself was enacted in 1994 to adopt the ancestral model law so that Singapore can offer a familiar arbitration regime to people who might want to arbitrate in Singapore. They might not be familiar with Singapore litigation, but if they arbitrate in Singapore, they are at least comforted that there is a known model for them to settle their disputes under. So by 2002, you have the Arbitration Act, which was pre-ancestral model law, and you have the International Arbitration Act, which is model law based. And therefore, it's thought that the two regimes should actually be synchronized, bring the Arbitration Act up to modern times. And so the Arbitration Act now follows very closely the format and ideas of the ancestral model law. But as I mentioned, Parliament decided to keep them separate because they thought that there should still be a bit more judicial control over domestic arbitrations. And that's why the two regimes were kept separate. There was some fine-tuning and amendments done to the International Arbitration Act as well. For example, in 2001 and 2002, there were a few controversial judicial decisions. One would be on the interim awards. Okay? Interim awards, as you know, would be an award rendered on part of the claim or on a certain substantive issue in the claim. But the arbitration will continue after that to deal with the remaining issues. So in one case, the court held that the tribunal can go back to revisit or reopen its decision in an interim award because it's not final. So that wasn't right. And Parliament then clarified in the IAA that awards include interim and final awards, and both of them have finality in the sense that you cannot reopen the award on the merits. Another kind of confusion arose out of this question of opting in and opting out of the International Arbitration Act. I mentioned that parties can actually opt out of the International Arbitration Act to go under the Domestic Arbitration Act, right, or the ancestral model law. So what happens if parties choose a set of institutional rules to arbitrate their disputes? Let's say the KLRCA rules or the SIAC rules or ICC rules, or even the ancestral rules. There were a couple of cases where this became a bit confused. One court held that if parties choose institutional rules, let's say ICC rules or even the ancestral rules, they have opted out of the ancestral model law, and therefore they opted out of the International Arbitration Act, and their dispute should be under the Domestic Arbitration Act. The court held, Parliament then quickly went to clarify that and said, no, you can choose a set of international arbitration rules or institutional arbitration rules. That by itself does not amount to opting out. And that must be correct because what the statutes provide will be statutory framework. Parties are still free to choose their institutional rules, which will exist against the backdrop of this curial law. Okay? Then there was another point of confusion. Say that, well, if you choose ancestral model law under the IAA, and then your agreement stipulates, let's say, ICC rules or ancestral rules, the whole set of rules will be thrown out because it's not compatible with the ancestral model law. So again, that was a mistake, and Parliament again clarified that you can choose a set of institutional rules and they can coexist within the IAA framework as long as they are not inconsistent with a mandatory rule or provision of the Act that you cannot derogate from. Okay? What provisions would there be that you cannot derogate from? It's not spelled out. But I would imagine that one example would be Article 18 of the ancestral model law, for example, on equal treatment of parties. Okay? That should be mandatory because there's no reason why a tribunal